Any mention? Your Lordship, I beg to mention item number 17, Your Lordship, because matter is pending in the division bench. Quashing of POXO proceeding, Your Lordship.
Item 17.
17, yes, Your Lordship.
Is it connected? 60 yes.
No, only 17.
No indication of when this division bench matter will be taken up.
So far, no.
No, Your Lordship.
Okay. Just wait for by the Lord Counsel for the petition and this is matter for 3 weeks.
3 weeks, Your Lordship.
Reply, please.
Yes, highly obliged, Lordship.
Your Lordship, I beg to mention item number 10. Kindly let this matter come after 2 weeks.
Don't want to do this matter.
My lord, I have no objections.
As per for the Lord Counsel for the petitioner. Comma not objected to by the Lord Counsel applying to the respondent. This is matter fresh. When?
After 2 weeks, Your Lordship.
Yes.
Highly
Keep me
obliged.
obliged.
May it please Your Lordship, I beg to make a mention of item number 6, Lordship.
Yes.
Lordship, I'm praying this matter may be listed after 3 weeks.
I have no objection for respondent 4, 5, and 6, lordship.
This is the same order. Make it 3 weeks. Yes.
Similar prayer of item number 12, Lordship.
Yes.
We have no objection, lordship, for respondent.
Same. 12 weeks.
Highly obliged.
May I please, Your Lordship? I beg to mention item number 15.
Yes.
Yes, ma'am. Okay. My lord, the similar matter is still pending before the division bench, my lord.
Now there are so many matters pending because of that.
Lordship.
Okay. That also make it 3 weeks as the request pending the petition. Yes, 3 weeks.
Lordship.
Wait, please, Your Lordship.
Yes.
I'd like to mention item number 13, my lord, hearing list. Making a prayer just for a week, my lord. Spoken to my learned friend from the other side as well.
I have no objection, Your Lordship.
The request of the petitioner. This is matter after 2 weeks. Yes.
Obliged.
Oblige, Your Lordship.
Item number 1.
None appears for the parties. The office note indicate that the affidavit of service in respect of respondent number 1 to 4 has not been filed by the petitioner. The petitioner, after post up, the petitioner to file the service affidavit before the next date. This is matter after 2 weeks. Yes.
Item number 2.
This matter, lordship,
Yes. Done appears for the parties. And list after 2 weeks.
Item number 8.
My lord, this matter, Lordship has heard us at length. Before concluding the matter, Lordship direct the government to bring on record additional facts. And they have brought on record, my lord. Recently, we have received a copy. So if Lordship give me only a week time, my lord, we'll go through and
There is an order directing them to file an additional
yes,
affidavit.
yes, and they have filed
That
it.
has been filed.
Yes. After Lordship conducted marathon hearing, that opportunity was granted to the
There was a marathon hearing.
There was a
when,
marathon
when it took place? Quite some time back.
quite some time back.
What is the matter about?
With regard to the appointment of a teacher.
You'll have to refresh the court again.
Madam.
When the affidavit was filed?
When it was filed? September, October. No, in the month of November, I think. November we filed it.
By now, we must have gone through the same.
My lord, we are unable to take instruction because of the intervening holiday.
Wait for by
Yes.
the London Senior Counsel appearing for the party, appearing for the petitioner. This is matter after?
After, my lord, a week.
Lordship, 8 and 11. 8 and 11.
At the same.
After 2 weeks.
After 2 weeks.
8 and 11 same.
8
Yes.
and 11 same.
There also affidavit has been filed.
Yes,
No,
the same
one-
affidavit.
one-
We have
one
filed one
affidavit.
affidavit
One
only.
of it.
One affidavit.
So 8 only will come after 2 weeks.
Yes, yes.
Just expect for the London Council to another
Why
party.
not together? Both are analogous.
Definitely, it will come after 2 weeks. Since
Together.
Yes.
is there any order taking these matters?
Yes, sir.
Yeah, yes.
Yes, orders
Before
there.
heard the matter also.
Tag
Yeah.
together.
Just say list after 2 weeks along with the WPC number 48 of 2008. This reiteration number.
Yeah. Keep the order.
Item number 9.
Yes.
On a prior
Yeah.
occasion, Lordship had heard the matter and it stuck up at a position where this petitioner, who was dismissed from service after 19 years, had initially approached the Allahabad High Court. And there was an order for disposal of the representation. Now, the Allahabad High Court
Please, Your
actually did
Lordship.
not have the territorial jurisdiction to try the matter, since it was Meghalaya High Court which was the correct one. After the disposal of the representation, we approached this Honorable Court by this writ petition. On the last occasion when the matter was heard, Learned ASG had given a judgment of My Lord Justice, thank you, which said that this would perhaps be a case of forum hunting, and Lordship wanted me to have a look into the matter. Because once he approached the Allahabad High Court, now he comes back to the Meghalaya High Court. Now, Allahabad High Court not having the territorial jurisdiction, his going back to Allahabad would not matter much. It had to be the Meghalaya High Court at all times. When I went through the judgment, I found that in that particular case of where the judgment was delivered, there he had approached the correct forum, the Tripura High Court. And thereafter, when he did not get the relief there, he tried approaching the Meghalaya High Court. In my case, it's the exact opposite situation.
But then in your case, the Allahabad High Court had entertained your petition.
It was not exactly an entertainment, it
not
was just a
rejected,
prayer
also-
for a disposal of the representation, and only that part was
Whatever it
allowed.
is, it has entertained,
Aye, aye,
assumed jurisdiction.
Aye.
So which way then it would be proper for this court to do?
So now, my lord, what the representation that was disposed of, there was a prayer only for the part of the payment of the pension, since he had already served 19 years from 1974 to 1993, and his final termination came in the year 2018. So what I would pray is, my lord, going by the recent Supreme Court judgments, which says that the Honorable High Court can actually entertain or reject petitions on the ground of equity and justice, even if there is some lapse on the procedure or on the other side. What I would pray is, going by the CCS rules, if I could impress Lordship to at least consider that he would be entitled to some compassionate pension on the ground that he was dismissed after 19 years of service, on the ground that he did not come back from leave, when the fact remains that he was under custody and he had tried to report back. go through that, my lord. I would take some time today. I mean, I don't think there's synergy. He's attending another court, and I have to also go back to Guwahati. A little bit of hurry.
Since I do not know, this court also does not remember what was argued.
My lord, yes, that, but the basic.
It appears from your submission that matter will not be that simple. It will have some.
It will have some.
Would you do one thing before you argument? You just give a note of your.
I'll do that.
Or you can do it after addressing those. But then if you give a written note, you do not want. You see, lengthy argument, written submission and all. Only the gist.
The gist. I'll do that one. Sort of a list of
the court does not meet any of the points.
I'll do that. I'll do that. I'll do that on the next day.
On the joint prayer of the parties. When do you want?
Could it be on the 7th of March? I would be coming back.
You want us?
What? I have another matter fixed. What I could do is, on the 7th of March, even if there's some difficulty on the other part, I'll just put in that the written submission that Lordship has said, and then it could be fixed for hearing after he goes through it. There's been no difficulty.
You do not have to make elaborate submission.
No, not an elaborate submission, just the because what I would state as a date or a fact, they may have some objection to that. Or if Lordship has it on any of the convenience of the court, no difficulty. Convenience.
After 2 weeks, on the joint prayer of the parties. This is matter after 2 weeks. If you have any difficulty and all, then later just you can arrange it.
I'm deeply obliged.
Oblige you, Lordship.
Item number 16.
The side is not there. No one paying for the petitioner. What happened? There is a problem. You see, the causally says after division bench is over. Something you say a problem. Non-appear.
That's item number 16. I'm waiting for petitioner. Lordship, let it come after 2 weeks, Lordship. I've taken consent from the private respondent as well.
Respect for the learned counsel for the petitioner.
Yes, no objection.
This is matter after 2 weeks.
Deeply blessed.
All right.
Item number 18.
My lord, this is
Before my lord, senior starts, my lord, Mr. Andy Shulai, he is on next, my lord, before quorum number 2.
Yes. What is the case about?
My lord, this is an application filed under section 482, my lord. We are praying for quashing of the FIR, my lord. The grounds that I've taken are number one, that there is no ingredients of the offence that has been alleged, that has been registered, my lord, and just they have brought in 2-3 sections just to make it actually. What is the FIR talks about? The FIR talks about, my lord, filing of a false FIR, my lord, filing of a false allegation, my lord. Now, false allegation would come under section 211 of the IPC, my lord. Now, 211 is not a cognizable offence; it's a non-cognizable offence. Now, in order to escape getting a permission from the magistrate to inquire, my lord, or to proceed with the investigation, my lord, they have put into other sections, my lord, which are cognizable sections, my lord. When these cognizable sections, there is no ingredient at all whatsoever when we even by plain reading of the complaint, my lord. So this is my case, my lord. Number one, there is no ingredients whatsoever of all the cognizable.
What is the law? You see, can under 482,
yes, my lord,
court can make an inquiry to find out whether the FIR at all concerns a cognizable offence or non-cognizable offence.
My lord, when in the context of the complaint itself, my lord, if it's very plain, even on a plain reading, my lord, if the contents of the FIR points out to such that there is an allegation of certain offence being committed here, and this FIR, my lord, which I am going to rely before my lord, is not an FIR filed by some ordinary citizen, my lord. It's an FIR filed by some IPS or MPS officers, my lord.
He's supposed to be expert in law.
My lord. So therefore, and very clearly makes a mention that this FIR pertains to lodging of a false FIR amounting to amounting to an offence under section 211. Now what does the IO does? The IO goes on to register more cases which are cognizable. So Malad, this is a classic example of the abuse of the process of the
Where is
machinery.
the FIR?
My lord,
Where is Mr. Sulai?
Lordship, he is on next before column number 2, my lord.
it's on petition. Why was not arranged properly? Yes, give me a second.
What are the status of what is the status of this case?
Lordship, actually, I'm not in this case, my lord, and I don't have the brief with me, Lordship.
Who is the assisting counsel? Who is assisting Mr. Sulai?
Rosie, my lord. I don't know.
Where is she? She's also not there.
No, Lordship.
So, my lord, we can take it on next week if this, or otherwise at the end of the board. But then at the end of the board,
See, there
just
will be a
switch.
division bench also.
Yes, my lord.
We do not know. Things are very uncertain here.
So we can take it next week, my lord, subject to my
We'll
lord's
have it after
availability.
2 weeks.
2 weeks, my lord.
At the request made by the parties. This is not after.
Deeply obliged.
Obliged,
You have to.
my lord. I know.
For you, see.
My lord.
The proposition of law laid down in Bhajan Lal's case.
Bhajan Lal, my lord.
See,
Yes.
it says that if the FIR doesn't make out any,
Yes.
say like cognizable offence.
Yes.
Now we have to make out from the reading of the FIR whether it is there.
Yes, my
We
lord.
cannot go into inquiry to find out. We cannot. You see,
No.
rest of
Yes.
the things will be revealed by
During the course of the investigation, my lord.
even under 155(2).
Yes.
The IO will have the the opportunity to seek permission of the magistrate to conduct investigation.
Yes, my lord.
That
But
is-
yes, my lord. But my point, my case is very simple, my lord. When I'm saying that yourself, you are saying, and that this is an offense committed against me, can the IO register some other section? Suppose if I am saying that
so we have to
theft.
we have to see that
Yes.
that on the basis of the allegation
Yes.
which is made out in the FIR,
Yes.
the registration of case under cognizable section of
Yes.
law is not at all possible.
Not at all possible, my lord. Obliged, Lordship.